Did the machine really fail, or did it just have a very bad day at work? When you're trying to prove a defective product caused an industrial accident, you are basically playing detective with gloves on and a hard hat. You start with the product itself, because the thing that hurt you may also tell on itself. We look for broken parts, burned wires, missing guards, weird wear marks, and anything that says, "I was not built right." Then we ask what the machine was supposed to do and what it actually did. If a saw was meant to stop when a guard opened but kept spinning like it had a superhero contract, that matters a lot. You also need proof that the defect existed before the accident, not just after the damage party started. That can come from repair records, photos, recall notices, warnings that never reached workers, or other people who had the same problem. Experts help a lot here, because they can explain the why in plain language. An engineer might say a part was weak, a safety tester might say the design was sloppy, and a mechanic might say the machine was running on wishful thinking. We also check how the product was used, because companies love to say, "It was user error," like that ends the story. If the worker used the machine the normal way and it still failed, that helps show the product, not the person, was the problem. Chain of custody matters too, which is a fancy way of saying we keep track of who touched the evidence and when. If the machine got tossed, fixed, or accidentally disappeared, the defense may try to argue the proof got scrambled. Photos and video can be gold, especially if they show the scene right after the accident. A clear picture of a snapped cable, missing shield, or leaking valve can say more than 100 sleepy meetings. Witnesses matter as well, because people nearby can tell us what they saw, heard, or smelled. Maybe they saw sparks before the blast, or heard a bang that sounded like a toaster fighting a jet engine. Maintenance logs can be sneaky useful, because they show whether the company kept the equipment safe or treated it like a neglected houseplant. If warnings were ignored or repairs were delayed, that can support the case that the defect was not some random fluke. Sometimes there are recall reports, complaints, or past accidents involving the same product. If the same model has caused trouble before, that is not a tiny clue, that is a neon sign doing jazz hands. You also need to connect the defect to the exact injury. It is not enough to say the machine was bad and somebody got hurt, because the law wants the chain of cause and effect to be clear, like dominoes falling in a very expensive line. That is why timing matters so much. If the failure happened right before the injury, and the worker had been using the machine normally, the story gets much stronger. Industrial accidents can look messy, but the proof usually comes down to simple questions. Was the product defective? Did that defect exist before the crash? And did it cause the injury in a way we can explain without smoke and magic tricks? If you are dealing with this, the big move is to protect the evidence fast and get help from people who know how to read it. Want to learn more about our company? Check out our links in the description.